during discovery, Mr. Bakir was almost uniformly referred to by Mr. Kemp and by Mr. Marlowe as the Russians. And the next motion would be motion to eliminate number 3.
That's regarding Scientology, right?
Yes, sir.
Okay.
The product itself, Your Honor, we're moving from the Russians to the Nazis.
Yes, we are.
This is UNFW's motion to eliminate number 6 concerning rocket fuel and German rocket fuel and Nazi rocket fuel.
All right. Department 16 is now switched on. Please be seated.
And good morning. Let's go ahead and set forth our appearances for the record.
Good morning, Your Honor. Eric Pepperman.
Good morning, Your Honor. Teddy Park on behalf of
Good morning, Your Honor. Jim Neale on behalf of UNFW.
Good morning, Your Honor. Nicholas Hoffman, UNFW.
Good morning, Your Honor. Joel Odou, on behalf of Real Water Inc. and AffinityLifestyles.com.
Good morning, Your Honor. Star Rasmussen and Brittany Lyons on behalf of Hanna Instruments.
Morning, Your Honor. Jim Cavanaugh for Real Water Tennessee LLC.
Morning, Your Honor. David Spurlock, UNFW.
Good morning, Your Honor. Rob Robinson from Milwaukee Instruments.
Okay, good morning once again. And I guess this is a continuation of the motions in limine, is that correct?
Yes, Your Honor.
Yes, sir.
Mr. Park, I thought you were standing up to tell us that it was a little settlement.
Yeah, I wish I was standing after that purge. We haven't worked it
There
out.
should be.
We're working on it.
I
Your Honor,
understand.
I just had a
Hopefully the motions in limine will help.
absolutely, Your Honor. I just had one housekeeping point I wanted to make. When Mr. Neale and I argued the motion to strike, Your Honor asked us about the dates, the 16.1. We provided both Mr. Neale and I alluded to, referred to, and I think even gave the court a copy of UNF's second notice of compliance. The original notice of compliance, none of us provided. I looked through his briefing, my briefing, and my notes. And I want to just give the court a copy of the initial UNF 16.1 disclosure, which was dated October 15, 2021, approximately 15 months before the second notice of compliance. And if I could provide one to Mr. Neale, just to assure him that this is a document, I'd like to give the court a copy of the
And
original.
you may approach Mr. Park.
Thank you, Your Honor.
And I just want to make sure this goes with what motion?
The motion to strike.
Okay. Okay.
That's the only housekeeping matter I have, Your Honor.
Which one's that again?
That's Plaintiffs Haley and Belsky's motion to strike UNFW's case, which would prohibit using fake Whole Foods records.
Can you keep this one? Okay, so where do we leave off?
Your Honor, Joel Odou for Real Water. I have one additional housekeeping matter.
Sir.
Your Honor, Friday at about 4:30, we all were served with some documents in the bankruptcy court indicating that there has been a proposed settlement between the bankruptcy trustee and the insurance carriers for Real Water. What that all means is subject to a lot of questions that a lot of people have, including myself. I do not have the answers to that. I just wanted to alert the court that there was this motion that also seeks to enjoin this case and a lot of other cases. And I imagine there'll be responses to that motion. I just wanted to alert the court that that motion exists.
I understand. Any idea what the timeframe's going to be on that?
I do have some comments to that, Your Honor.
Yes.
So basically what we have here is we have approximately 30 million of insurance on the Real Water side. And the way I calculate that is there's about 4 million a year from Liberty, 3 or 4. Let's say there's 4 for 4 years, 16, 17, or 17, 18, 19, 20. So that would be 16 million. There's another 5 million allegedly from Real Water, Tennessee. There's another 7 million that they tendered to Great American for 2 million and National Union for 5 million. And then we found a couple of co-packer policies. Co-packers are the people out of state who package the product. So I'm assuming there's approximately $30 million in insurance. So here we have And then some of the victims in this case have actually made offers of judgment that have been rejected, so they have a limited insurance article. All right, so we have 30 million with limited insurance, we have some victims with unlimited insurance, and we have judgment day coming. In what I would characterize basically as an absolute liability case from real water's perspective. So we have judgment day coming, and 18 months ago, we entered into a stipulation and order with the bankruptcy trustee. And our agreement was that we, the plaintiffs, would not seek to pursue real water and that we would content ourselves with the insurance policy. That was the agreement made. It's reflected in the stipulation. The bankruptcy judge signed the stip and entered an order. So now, the insurance company has filed a debt relief action in the bankruptcy court. They have sued Real Water in the bankruptcy court. Again, this is Liberty. All these other insurance companies, I don't know if they have a dog in this fight yet, but Liberty has done this. They sued the bankruptcy, the Real Water in bankruptcy. And then Mr. Odou told me about 2 or 3 weeks ago that Real Water was not going to put up a defense to that. So plaintiffs, because there was not going to be a defense to a declaratory judgment action seeking to declare the insurance null and void, on one of the grounds I think I mentioned, they argued that Blaine Jones violated the cooperation clause by suing them. That's one of the grounds that they've alleged in the debt relief action. So Mr. Odou says, well, Real Water, we're not going to defend that. And I said, okay, fine. I will file a motion to intervene and we will defend the coverage litigation. So we filed a motion to intervene in the bankruptcy court. Now, this brings us directly to the current.
I mean,
motion.
there's some bad faith issues and a whole bunch.
Well, there's bad faith issues. If the verdict for the plaintiffs who have made the offer of judgment exceeds the offer of judgment, there's a bad faith issue.
Yes, I understand.
Okay, there's some real other interesting issues that I'll get to in 2 seconds. So, since they see where this is going, there's going to be a big judgment entered against them, probably about 6 weeks. They run, well, take that back, probably 10 weeks. So they take that back. They run the bankruptcy court and they engineer this thing. Okay, I see a couple problems with it. One, they're reneging on their original agreement in the stipulation. Okay, they are backing out of the stipulation. And we've been prejudiced because we did not pursue issues in the bankruptcy court that you would normally see plaintiffs or victims pursue, such as monetary transfers to the principals within the 2-year period of filing bankruptcy. We let it go, Your Honor. In addition, we pursued the litigation. Not just our case, there's 17 cases filed here that have been vigorously pursued. So there's a stipulation, there's an order, now they're trying to back out of it. I really doubt the bankruptcy judge is going to let him do that. But if he does, we get to the second problem, which is what I view to be the overwhelming obstacle, and that is the Anti-Injunction Act. That is a federal statute that specifically says that a federal court, in a bankruptcy court's a federal court cannot bar a state court proceeding unless the 3 exceptions are met.
I kind of think I know where you're going here.
Okay, so I mean, I view this as, I don't even know if I call it a Hail Mary. It is a pretty desperate action, okay? So assuming that they comply with the Anti-Injunction Act, and the only argument they have is it's in aid of the court's jurisdiction. Okay, so now the insurance company goes in.
And also, I would think when it comes to coverage issues, typically those are handled in state court.
They are handled in state court, Your Honor, and especially where Mr. Odou said that they weren't going to contest the coverage declaratory relief action. Now they put on their thinking hats and said, oh, let's manipulate this and try to get a bar on all the state court actions. So anyway, that's prohibited by the Anti-Injunction Act. The third problem, which I think is really as bad as the Anti-Injunction Act problem, is the deal they cut. Okay, I told you they had $30 million potentially of insurance. The deal they cut is that Liberty Mutual pays $4 million into the insurance court, and the bankruptcy trustee and his attorney get a 10% cut of that. In other words, they get $400,000. And then the other 3.6 gets divided among the 80 or 85 victims in this litigation, which works out to something like $38,000 a piece. okay? So that's the deal they cut. Okay, I see a couple problems. First of all, the debtor is getting nothing out of this deal. What possible interest could the debtor have in this? Now, true, the attorney for the debtor is getting the 400 Gs, but the debtor gets nothing from this deal. So I don't see how the bankruptcy court is going to approve this. So with regards to timing, they have noticed this motion, and the motion is characterized as Rule 60 motion to modify the orders. And unlike this court, in federal courts, there's not a 6-month limit. The limit is you have to file it within a reasonable amount of time. I don't think it's going to be determined to be a reasonable amount of time that they waited 18 months after all this other stuff happened. But, you know, they may do it. So when we were wrongfully removed to bankruptcy court, another bankruptcy issue, and we filed a motion to remand, and we actually won that motion to remand after a contested hearing, that took the bankruptcy judge 6 months. And that was a relatively simple issue. They were arguing related jurisdiction. The distributors were saying, oh, we might have a cross-claim.
I feel good about 2 weeks.
Okay, yeah, all right. So that took 6 months. So, and that wasn't a hot issue, a hot button issue like this one. So I can virtually guarantee the court there's not going to be a determination of this on August 28th or 29th. And I also point out that they haven't even noticed this properly because they didn't give notice to everybody that's affected by this. They just gave notice to the plaintiffs that were involved in the bankruptcy proceeding. But in any event, it's going to have to be reset. It's going to be vigorously opposed. Assuming it's argued in October or November, you apply to 6 months, you know, there's not going to be a decision on this for quite some time. Okay, so where does this leave us? This leaves us with, you know, like I said already, I don't think this is a Hail Mary when we've got the Anti-Injunction Act involved. And I am surprised that they engaged in this, what I would call an audacious or risky gambit. Because I can only think of 2 times in my career where I've seen sophisticated people try something like this. One, in the tobacco litigation, the tobacco companies had a plan to enter into a prepackaged Chapter 11 and come out of it, but they ultimately didn't go with that plan because the bankruptcy court would be overseeing executive compensation, probably make RJR sell those 26 private jets. So they decided this bankruptcy thing wasn't a good way to go, and they wound up paying the $200 billion global settlement. Okay, that was the first effort. The second effort I've seen is recently in the opioid case. The attorneys for the Sackler family, who, by the way, I know Mr. Burdick real good. He's from Kirkwood Ellis. He's the attorney for the Sackler family. He convinced, or tried to convince, the bankruptcy court into issuing a stay of any litigation against the Sacklers, even though they weren't in bankruptcy. You know, let these people keep the $25 billion they made from Purdue selling these opioids. They get to keep the $25 billion, but any litigation against them is stayed. And that got rejected on appeal, although I think it's going up to the United States Supreme Court. So you have to be in dire, desperate straits to try this kind of bankruptcy tactic. Because first of all, usually it doesn't work. And then second of all, it potentially creates a serious liability on the insurance company. And what do I mean by that?
I get it.
So Liberty Mutual, in our view, has conspired with trustees council, and if there wasn't this $400,000, I'll be nice and call it an incentive. Okay, remember, these were the people that weren't going to oppose this 2 weeks ago, and now all of a sudden they're filing this motion because, lo and behold, they're getting another $400,000 incentive. Okay, I'll just call it an incentive. So you've got this insurance company, you know, what they do with Mr. Odou, maybe that's fine and good. They can plan all kinds of nefarious strategy, you know, because they have the attorney-client. But as soon as they go outside that and they get a third party involved, that, in my book, is collusion, concert of action, potentially a fraud on the court. I mean, you know, we have to go through the bankruptcy process. But after it's done, I think there's going to be some serious consequences here if we prevail. Obviously, if we don't prevail, there won't be any consequences because we'll be barred, okay? But in any event, so for that reason, Your Honor, I don't know if Mr. Odou was bringing this out as a preface to filing some sort of stay request with you, to be followed up with a stay request to the Vascular Court. But I just want to put it all on the record, what we know. This is what we know so far about this particular maneuver, okay? I think we're going to find out some stuff in the next coming days or weeks that is even more alarming. But this is what we know so far.
Mr. Odou, what do you want to
Just very briefly, Your Honor, the only thing I would add is I'm not coverage counsel, my firm is not coverage counsel. We're not a party in the we're not attorneys in the bankruptcy court. I have zero knowledge of any of those things. There are, to correct the record, 27, 29 cases, depending on how you count them, and 101 plaintiffs. That's the only correction I would make.
And I forgot one thing Mr. Odou reminded me of. They are refusing to sign the stipulation to allow Blaine Jones to file his case. The bankruptcy trustee sent Mr. Christiansen an email Friday saying, we're not going to sign the stipulation, so you can't be a plaintiff. And I just bring that up because we may have to revisit that motion eliminating with regards to plaintiffs at some point.
Your Honor, Scott Rasmussen on behalf of Hanna Instruments. I only stand on for this ground. Not in this case. I want to make sure that I've said that to this particular court. Cross claims against real water by the defendants. I do not have one with regard to Hanna in this case. Make sure that I've said that. But this particular motion can affect some of the defenses and other things that may happen in this case, let alone cross claims that may have been filed in this particular case and others. And so with that filing of the motion, I'm just concerned about moving forward where, as you know, and we have been here many times when these sort of things happen in large CD cases, the bankruptcy court comes in and says, hey, we have to deal with this issue. And from a lot of different perspectives, perhaps this can affect some of the other defendants in this matter. So I'm just making sure that before we go down a road of let's just keep going forward, and which I'm surprised, but I can't imagine it won't be filed by the plaintiff, something to say to the bankruptcy court moving forward with this trial would be something that the bankruptcy court could allow based on what's been filed, as opposed to just in conjunction with maybe some other things that they will be filed. My client is not in bankruptcy court, but our cross claims in other cases and things like that could be greatly affected by what is happening and what could continue to happen, as Mr. Kemp alluded to, several different insurance carriers that may take the same positions. We just don't know, but what we do know, the fact is we have a motion that was filed. I don't believe this court has had an opportunity to review that specific motion. It's only been told to you from Mr. Kemp's perspective of what it claims to say. So I think first you would need a chance to review it, look at it, and then make some decisions based on what you see, as opposed to just going at it.
Well, I can tell everybody what my initial impression would be. And it's really this simple when it comes to bankruptcy court. Of course, I respect a specific scenario where a defendant and or plaintiff might file bankruptcy, right? Then we have the automatic stay in place, et cetera. And I've always respected that. In fact, I have some experience regarding the automatic stay, and that's seeking relief to, to proceed against insurance proceeds, right? But here's my point. I don't know how, unless there's a filing of bankruptcy by one of the parties to this litigation, I don't see how a bankruptcy court has any jurisdiction over this court. Because at the end of the day, we know this, when somebody files bankruptcy, the automatic stay goes into place. And it's automatic. I just have to be notified of it and everything stops. But until that happens, we're proceeding forward. I mean, I think it's important to point that out because, and if somebody would have to really explain to me, unless there was a bankruptcy filing, how a bankruptcy court could stay a general jurisdiction court. I don't see it. I mean, I just don't. Without even digging deep into it. But of course, if there's some exception out there for me to consider, I would. But in a general sense, this case will move forward. That's kind of how I look at it, right? And there's been a lot of time, effort put into place as far as prosecuting this case. We just happen to be first up. And there needs to be some resolution. I find it fascinating that things are going on there. I mean, I don't know who, what, or why, but I can see where that potentially could open up insurance policies. I see that too, right? And I should say coverage, limitations, but fascinating. Maybe someone needs cumulus points. I don't know. Right?
Another housekeeping matter I
Yes.
talked to Mr. Neale about. We have a special master hearing at 3 o'clock today. I think we made the court aware of that.
Oh, I have, look, I'm here until you need to go.
I think we need to get out of here at 2:15 at the latest.
Yeah.
More likely 2.
Yeah, because you're going to jams, right?
Yeah.
Yes.
I tried to drive over and across town traffic, and it took every bit
Oh,
of
it's tough.
50 minutes.
It's different. There's no question about it.
Every road in Las Vegas is under construction at the moment.
Everywhere, it's the 215, it's the 95, it's the 15. There's no question. And then if you do happen to have an accident, it's impossible, everything shuts down, for the most part. Okay, I get it, I do respect the information, and we'll see what happens, as far as that's concerned. But anyway, where did we leave off?
Your Honor, we last argued UNFI or UNFW's motion to eliminate number 2 on the immigration and criminal,
Right,
immigration status and criminal history. I believe that is submitted to the
right.
court. And the next motion would be motion to eliminate number 3.
That's regarding Scientology, right?
Yes, sir.
Okay.
And Your Honor, I'm sorry, one of the other things the court asked for was Whole Foods 180 on the motion to strike.
Yes.
And I
Is that
have
a
that.
transcript?
I'm sorry, sir.
Is that a transcript? Was that it?
This is a paper copy of the spreadsheet.
Okay, I got you.
Mr. Pepperman's reviewed it, and if I may approach, I'll enter
Mr. Pepperman, is it fine for my review?
Yes.
Okay, you can hand it to the court. Hold that for me. Thank you, sir.
Thank you, Your Honor. Your Honor, Jim Neale on behalf of UNFW on our motion to eliminate number 3 to exclude any mention of Scientology. I'll be very brief and then ask the plaintiff to weigh in because I think there's substantial common ground here. This
It
motion
did appear to be.
parallels Real Water's motion to eliminate number 7 as well. So basically, Your Honor, this is the story. The Jones family, as I understand it, were Scientologists. They were encouraging their employees to be Scientologists, and they were encouraging / coercing, some employees would allege, those Scientology lessons. There were some alleged mandatory meetings, materials, expectations regarding progress. There's a unflattering story to be told there, Your Honor, that resulted in, as I understand it, some litigation between former employees of the company and Real Water. We want to keep all that out, Your Honor. We don't think that the Scientology is relevant to the product defect issues that are at hand in this matter, and so under 48.015, we would move to exclude those. I believe there's general consensus, but I'll let the plaintiffs articulate where they can agree with the motion, where they have to reserve some opposition.
All right.
And Your Honor, Real Water is joined.
Okay, thank you, sir.
Your Honor, as the limited opposition indicates, there is general consensus. We don't intend to go into the story of Scientology or the prior litigation to any extent. Our concern only is that this is a very general motion on general topics. If you consider Real Water's correlating motion, it includes politics and family squabbles, and our only concern is that some of this, in terms of references, may be weaved into certain video testimony or may be important in the terms of context. And I don't know that it is because there's nothing really specific that's been identified. But to the extent that there is something that we can't edit out because it references Scientology of a video deposition that we play at trial, or to the extent that it may be necessary in terms of a minor reference to context, to some of the testimony, we just don't want to be, we don't want to have a non-opposition viewed as unable to raise those issues with the court. So I guess in sum, we don't dispute the motion, we agree with it. If there's something that arises that relates to Scientology or politics or family squabbles that we believe is important to the context or can't be edited out reasonably, we would raise that issue at the time before we introduced it outside the presence of the jury. We just don't want to be taken and put in a position when if that time comes to say, no, you didn't oppose this motion, it's the subject of a motion to eliminate, you can't raise it now. That's our only concern.
Your Honor, so long as there's no mention of Scientology without first previewing it among the parties in the court, I think we're.
Yeah, and I'll grant the motion. And remember, motions in limine are interlocutory in nature, so if something comes up that's an issue, we can deal with it.
Thank you, Your Honor.
All right, so we're subject to that condition.
Very good.
Okay.
Motion to eliminate number 4, Your Honor, for UNFW deals with alleged OSHA violations, the Occupational Safety and Health Administration, and UNFW has moved to exclude those as well. Your Honor, the court granted our motion to eliminate number 1, excuse me, that's not right. The court denied plaintiff's motion for summary judgment number 5 on the issue of adulteration because regulatory compliance was different than product defect. And if regulatory compliance is different than product defect, then certainly employee safety and health regulatory compliance is even further afield from the product defect, which is.
But tell me this, though, isn't it slightly different than that?
I don't believe it is, Your Honor.
Well, I can tell you what I was thinking about, because I did read the motion in limine, and there was issues regarding specifically the practices that were going on during the time period. And I thought that was that's what I thought was the real thrust of the opposition, because they were talking about problems that were specifically occurring as it relates to quality control. And here's my point, for example, there was no quality control person, right? They hired a receptionist. And the reason why I bring that up, that's kind of I don't mind telling everybody this, I thought that was kind of a big deal. Because here you're having a consumable product, right? And you don't have a QC person. And then you promote the receptionist to the QC person.
Judge, let me be clear, we're not trying to keep out that evidence. That's not an OSHA violation.
No, I understand, but that's, well.
And I think that John, if you could pull up Exhibit A, please, the deposition transcript of Ms. Converse, starting on page 24 of that. That's not the PDF page, John, but it's the.
Yeah, because I was kind of looking at her deposition, starts out, quote, who was the director of quality control at the time you became? You were a receptionist, there was nobody.
Right. And, Your Honor, that is not the subject of the motion. That's not an OSHA violation, that's not an OSHA matter. The plaintiffs remain absolutely able to point out quality control issues because those are quality control issues, and those go to the product. There's no beef there. What we then get into the alleged OSHA issues, which involve, and I think part of this is just confusion on Ms. Converse's part. The opposition says that Ms. Converse testified there was an OSHA violation related to the pH testing of water and the maintenance of records related to those tests on every shift. I want to be perfectly clear. If the plaintiffs have evidence of substandard testing or record keeping regarding water quality testing, that's not the subject of this motion. That's not an OSHA violation. All we're trying to keep out here is the Occupational Safety and Health Administration's visits, the electrical cords across the floor, the fines that they made. So John, if you could go down, please, to starting at line 21 of that page. Let me back out just 1 second so the court can see the question there, John. Starting at 15, if we could, forgive me. This is Ms. Converse, the receptionist turned quality control director, talking about OSHA complaints, not violations, but just complaints. And one of the reasons that there's so many motions in this case is because I think there are some liberties taken with the record. An OSHA complaint is not a violation.
No, I understand the distinction.
It's a complaint. And so to characterize it, one of the things that we're afraid of is that things like complaints about electrical cords across the floor get turned into OSHA violations that the jury believes affect product quality, and that's not the case. So as she says here, there's electrical cords on the floor, there's no hot water in the back for the guys to wash their hands with. Going on to page 25, John.
But aren't those quality control issues?
No, sir, they're not. Electrical cords across the floor are not, and
The telling to wash your hands, that's not in hot water, that's not a quality control issue.
well, I think it's certainly not a hydrazine issue, Your Honor,
Well, I
which is
understand that, we'll get to that later.
which is the
Based
plaintiff's
upon
theory.
my- Yeah, I understand.
Theory of the case. If we were here on an E. coli case or salmonella case, it might be an entirely different. But I think therein lies the danger and the risk, and there have to be some guardrails around the evidence that the jury is asked to consider here, and I think that asking them to consider OSHA violations. Now, if NSF, the food safety auditor, comes in and says, hey, the water temperature is not adequate for sanitation, that's fair game. But the OSHA inspectors aren't looking at it from that perspective at all. She says, I did my best, I did it all, I fixed it. The other point here, Your Honor, is that Ms. Converse leaves in 2017. August of 2017, long before the water that any of the plaintiffs in the Gallagher case are alleged to have consumed and caused an illness. Scroll down, please, John. So, Your Honor, I think that employee safety is not consumer product defect. It should stay out for that reason. The timing is off. This is years before even the earliest injury in this case, which I believe is Mr. Belsky's in May of 2018. And none of it has anything to do with the alleged defect, which is the hydrazine. Plaintiffs can talk about whatever quality deficiencies they have evidence of, but it ought to be in the context of a quality inspection, either from Southern Nevada Health or NSF or an internal audit or something of the sort, rather than employee safety and well-being. So that's the motion, Your Honor, and we'd ask that the court grant motion eliminating number 4 and keep out the allegations of OSHA violations and any violations themselves.
Okay, thank you, sir.
And again, real water to join these, Your Honor.
Okay, thank you.
Your Honor, just so you understand, we want to withdraw our joinder for this particular motion. So there's a joinder in this action, and Hanna Instruments withdraws its joinder.
I understand, I can anticipate. Okay, Mr. Barger.
Yes, sir. Your Honor, the motion appears broader than what Mr. Neale said. The actual caption of the motion is motion limiting number 4 to exclude Real Water's interactions with OSHA, as opposed to simply OSHA citations. So if Mr. Neale is only concerned about the OSHA citation themselves, I would have thought that he would have listed those citations, the date numbers, and then the court could have dealt with those citations specifically. Because under the Brunswick case that's mentioned in the papers, Your Honor, and I can tell if you read it given your comments earlier, if the citation is actually meant to not only protect the employees, but also protect the potential plaintiffs involved, like hot water, pH balance, then those are exceptions to the Brunswick case and would be admissible. So without the court seeing which citations they're speaking of, I don't believe the court can grant the motion, certainly not as broad as the motion appears to be. I do agree with Mr. Neale in that if the citation is not designed in part to protect these plaintiffs or the public based on consumption of that water, then I think he's right. But beyond that, the Brunswick case says that there could be admissibility, these documents can be admissible if they're among those to protect the plaintiffs currently involved in the public, Your Honor. And you certainly pointed out, Your Honor, Ms. Converse's deposition testimony, which is on page 3 of the plaintiff's opposition, where she mentions that they were supposed to check the water level, the pH levels on every ship, and the records needed to be up to date, and that was not being done. And so, in addition to hot water and pH testing, I would say, Your Honor, there is inadequate information in the motion to grant it based on its broad terms at this point. I would suggest that to the extent there are CFRs or OSHA regulations that they're concerned about with specific citations, they should have been identified in the moving papers, and they're not, Your Honor. If you look at the motion and the reply, not a single CFR is identified, not a single particular citation with a bait stamp number is identified. And so I think, Your Honor, the motion should be denied, and at the very least, denied in part, granted to the extent that UNFW can demonstrate that particular citation did not have any corollary or ancillary benefits to the public at large on QC purposes. And then the other thing I would mention, Your Honor, in terms of interactions, I think Mr. Neale has conceded that if interactions occurred between Real Water employees and OSHA that actually prompted Real Water to make changes in its QC policies, then that would be important and admissible. And then the only other thing I would mention, Your Honor, is there's been no evidence that the QC policy or lack thereof changed after Ms. Converse left. Mr. Neale indicated that she left in 2017, but has not produced any evidence to demonstrate that someone more competent was brought in or that wholesale changes were made in the company's QC policies and procedures. So on that basis, Your Honor, we would ask the motion be denied.
Okay, thank you, sir.
Thank you.
Your Honor, the reason that there's not a specific CFR and citation that are cited chapter and verse is because none's been produced. We've given you what we have on OSHA violations. Those are Ms. Converse's misguided and imprecise recollection that's quoted at pages 24 and 25 of her deposition. And then Exhibit B is a back and forth between Ms. Converse and OSHA, John, if you pull that up, please, about how to pay a fine. But there's no indication at all of what it's for or anything of the sort. The problem here is that there is no OSHA violation for the water testing or anything that's QC related that we can point to. And so we shouldn't have Ms. Converse erroneously trying to recall something from 7 years ago that she's just frankly got wrong. John, if you could...
But see, here's the point. It's not up to me to decide what she got right or wrong. I mean, if that's her recollection, that's her recollection. I mean, that's important to point out because she was a witness. She was there. And so I'm not gonna weigh in balance and say she was wrong. She might be dead right. And I don't know. That's gonna be up to the jury. And I don't mind telling you this. I think quality control's on the table.
Absolutely it is, Your Honor. There's no disagreement there.
Business operations, that's on the table. And if there's no citations, there's no citations. But if she remembers specific concerns they had, for example, not washing hands or cords all over the place. And the reason why I think I can see where that's important, and remember this, I remember lawyers would sometimes say to me, they say, well, Judge, you know, that evidence is prejudicial. All evidence is prejudicial, right? To the adverse party. Is it unduly prejudicial? That's the standard, right? You know, and that's why I wanted to bring that up. All evidence is prejudicial, right? And we all know that. I know we do. But I'm just looking at it through this lens of it has something to do with business operations, quality control, those types of things, and that's her recollection. She was there.
She was, Your Honor. And I understand the court's ruling, and I'll move on after I say this.
Okay, go ahead. No, go ahead.
The final pitch I'll make is that there's a difference between Ms. Converse saying, this is what I recall, this was the issue, this is what I tried to correct, and putting the imprimatur of a federal employment safety agency complaint or fine or violation on that. What, just as the FDA's declaration of adulteration is something separate and different from product defect, so too would be an OSHA fine, or an OSHA violation, or an OSHA citation, or even an OSHA complaint. And so while the substance of the complaint regarding QC, even if it's wrong, is fair game, as I understand it, under the court's ruling, we should keep out the employment agency's quasi-judicial administrative findings.
But we don't, do we have the findings? We don't have them.
We do, Your Honor, they're exhibit, we have an email here talking about OSHA paying fines. That's the best, Real Water paying OSHA fines. That's the best I can do. We have Ms. Converse talking about OSHA complaints. And when we frame it in terms of what the company has done wrong administratively, I think what we're inviting the jury to do is to speculate not about whether the product may be defective, which is what I understand they're here to do, but instead whether they ought to fall in line with the OSHA inspector and use his clipboard or her clipboard as a shortcut for their own deliberation. And I think that's the risk here, that's the danger. It's a particular risk because the aims of OSHA are so very different than protecting consumer product safety, which is what this trial should be about.
Anything about the fine, Mr. Parker?
Your Honor, the fine, I don't need that document. And I can consider, I've considered what Mr. Neale said in terms of the fine. The interactions was the name of the actual motion. So in terms of this document, I'll stipulate that we don't need that document to talk about what the fine amount was. They're asking to reduce the fine, that's fine. I don't need that document. The interactions, the QC component of this, I think is paramount in what we're trying to explain to the jury. And the jury should be able to decide what Ms. Converse recalls regarding those interactions and the changes they had to make for QC purposes.
And you get the last word, sir?
No, sir, the court understands the issue.
Okay, yeah. I'll grant it as to the fine, but as far as quality control, business operations, those types of things, I think that can be potentially directly correlated to the product itself. I mean, I see where that's relevant, how they're running the place. And this is important too, the fact that she was at one time a receptionist and then became the quality control person. You know, because I don't mind saying this, that kind of surprised me when I read that. It really stuck out to me because I was thinking, wouldn't you want to have a chemist at a minimum, something like that sit in that position? You know, at least that someone from the College of Southern Nevada was taking a chemistry course or two, right? I don't even know if that would meet the requirement, but I'm just saying, from a good faith perspective, that's what you want, right? That's how I look at that. Okay, let's go on to the next one.
Thank you, Your Honor. UNFW's motion to eliminate number 5. John, could you put up a picture of the titanium tubes, please? Judge, this seeks exclusion of characterizing the source of these titanium tubes as the Russians, if I can. These are pictures, Your Honor, of two, what's been referred to in this case as titanium tubes. These are the tubes through which Real Water routed its purified source water. They applied an electrical charge to the threaded ends, the anode and cathode there, and then they put some plastic tubing on those 4 outlet, I don't know what to call them, prongs, and that separated the positive water from the negative water. And it's in this titanium tube that the plaintiff's expert alleges hydrazine was inadvertently manufactured. There's, I think, no dispute that Mr. Brett Jones acquired these titanium tubes from a gentleman named he acquired them from John Marlowe. And John Marlowe, the inventor, if you will, of Real Water, as the parties have all refer to them, acquired those same titanium tubes from Vitold Bachir. That's Vitold Bahkhir. During discovery, Mr. Bachir was almost uniformly referred to by Mr. Kemp and by Mr. Marlowe as the Russians. And I think that we'd be
But I
better
don't
off.
think Mr. Kemp invented that term, did he? I mean, that was Mr. Marlowe.
I think Mr. Marlowe was the first to use it, Your Honor. I don't mean to cast an aspersion there. That was the description. I just don't think it's an appropriate description. This is a gentleman who was a Las Vegas resident. He's since moved to Ohio. We know nothing about his citizenship, but I think that we ought to keep in mind that we're involved in what's essentially a proxy war with the Russians, and that a characterization of an individual who has a name and lives in the States, presumably legally, carries with it some negative associations. The plaintiff, it's telling, I think the plaintiff's opposition says that their job is to paint a verbal picture, and I think that's clearly what's happening. The other thing that's interesting is that the response in opposition here is combined with the next motion in limine that refers to Nazis and Germans. And this is an effort to paint a picture. It's an effort to convey to the jury that the man who supplied these was part of the bad guys. And I just think that given the current events, Your Honor, given the likelihood that we may have some juror who is Ukrainian American or Eastern European or an opponent of the military excursion into Ukraine, that we don't need to be characterizing somebody whose name we know as the Russians. When you attribute something to a bad guy, it becomes a bad thing. I think that's the picture that the plaintiffs are attempting to paint. Again, the plaintiffs can say that Marlowe flunked chemistry. The plaintiffs can say that Marlowe didn't invent this. The plaintiffs can say that it didn't come with operating instructions. The plaintiffs can say whatever substantively they want to say about these titanium tubes, but to give the jury the impression that they were handed off in a dark alley by someone wearing a trench coat and described as the Russians, I think crosses the line. And for that reason, Your Honor, we ask that the court grant the motion.
I understand.
And again, Your Honor, real water to join this motion. Thank you.
My only question is, what do we do when Mr. Marlowe, the inventor of real water, referred to
I believe he may be testifying via video,
Back
given his
here.
age. And obviously, we would work with the plaintiffs on if there's an editing problem, but I won't speak for the plaintiffs.
Your Honor, I don't know that Mr. Marlowe is unavailable. He twice appeared in person for depositions. If he is unavailable, I agree with Mr. Odou that it's a simple matter to edit a video and substitute a name for that term. I think Mr. Stevens can do that kind of thing in his sleep, and so that'd be the suggestion. If he does testify by video deposition, if he appears in person, the court instructs him, and like all witnesses, he follows the court's instructions.
You know, we're hoping to have him live, but I think he's about 80, so maybe we won't have him live. In any event, can we have the testimony, please? Judge, this is the actual testimony, and I would point out that this came from his 2021 deposition 2 years ago, prior to the time period that we had the Ukraine conflict. So the suggestion that was just made, that we introduced the term Russian to take advantage of any hostility with regards to this Ukraine conflict, it's simply absurd. This was before the Ukraine conflict.
Mr. Kemp, I'm sorry, sir. I didn't mean to make that suggestion. I apologize if you heard me.
Okay. And this is his testimony, Your Honor. As a
Well,
result
that's
of...
kind of my point, though. I mean, it's one thing if you, during the deposition, you said, well, we got this from Russia, this technology, and you said, you mean the Russians? And you see where I'm going on that?
You are going to have to sanction this guy 15 times to keep the word Russia out if he appears live. I mean, I guarantee you. But in any event, here's the witness. As a result of all this catalyst work I did, I encountered a gentleman from Russia. His nephew and niece were living here in Las Vegas. He had developed an electrolyzing device in Russia. Okay? Then we get to the set. That's the first 2 times Russia comes up. The witness brought it up. the third time. So this was the initiation, this person from Russia, yes, okay. I said this person from Russia because that's what he called it, this person from Russia. Didn't use the name, and then I think the name finally came up in his second deposition. And then he says, well, what do you call this thing? And I go, FEM, I don't know what that stands for. And I say, so they, and I thought he was referring to real water. So I say, so they being real water, not only were we not trying to insinuate that the Russians had something to do with this, we thought it was real water. And then he says, the Russians. And I go, oh, the Russians called it that. And he says, yeah. I mean, this is pretty innocent stuff, Your Honor. I'm surprised that there's a motion in limine on it. And like I've already said, if he does testify live, and I think he will, you know, I don't know how you keep this out of his mouth. And then if you instruct him to use the name Batol Bakir or whatever the Russian's name is, I think that creates even a worse situation because that's obviously a Russian or Ukrainian name. I mean, I think it's potentially the same problem, but with a different name. So I don't think there's any basis for granting this motion, Your Honor. And counsel did say that he thinks we're going to try to paint the perfect picture that this was some Russian conspiracy to, you know, to poison Americans. We're not trying to do that, Your Honor. I don't anticipate even bringing up the fact that this guy's Russian in the opening statement, but I do think Mr. Marlowe will have a very difficult, if not impossible, time telling his story without referring to these people as the Russians, which he's been doing for the last 35 years. And I also point out that Mr. Blaine Jones and Brent Jones, in their testimony, they call it from the Russians too. I don't even think they knew the guy's name. So for that reason, this motion should be denied.
Your Honor, we just filed a joint here. We withdraw it with regard to its calling that the device didn't come from Russia because we do believe that's an important bit of information that our chemist has reviewed with regard to things which will be a part of what we do here in this trial. With regard to calling people Russians, it's a weird spot that I'll let the
Yeah, because this is totally different from our last discussion.
Yeah.
Last Friday, right?
Right.
You know, regarding somebody's immigration status.
Yeah, this product, according to everything that we've seen, came from Russia. It was not material or the FEMs, which we understand what they are. We understand where they came from. Would have had to have been built in or have been manufactured in Russia. We get that, okay? I don't know that others get that, but we need to have that in there because that's an important distinction of what we're going to be doing in our defense in this case. Saying that someone is from Russia, that's a different spot. That's why I thought I was joined in that specific spot, not that the word Russia can never be used in this case, which I don't think we can go that far, and I don't think we should go that far. I don't like anyone talking about anyone's ethnicity at all in terms of anything that has to do with this case. It doesn't, frankly, it doesn't matter. But where something is manufactured, so I do believe that there is some value to that.
I mean, that's a fact.
Yeah. Yes. I apologize. Yes,
I agree, Your Honor. It is a fact, and it's an important fact in society. This isn't a conflict, and it was going on before 2021 in the deposition of Mr. Marlowe the first time. Mr. Kemp raises some very practical considerations, and they're difficult for the court to deal with, but there is a heavy prejudice in this country, at least among a good portion of the population, against the Russians at this point. I'm very sincere about that. It's very prejudicial.
Your Honor, I'll leave it at this. We have the gentleman's name. We provided this to Mr. Marlowe. We should use it. There's nothing pejorative about saying that he acquired these and they were manufactured in Russia. But to echo what Mr. Cavanaugh said, we are at a geopolitical tipping point of sorts, and we should be respectful of that. And jurors may bring deep-held and intense feelings about that, one way or the other, in the courtroom. And I think that the straighter we can shoot during the trial, the less likely we are to run afoul of any of those. So I would ask that to the extent
What do we do about this though? And, for example, I have a high level of confidence that counsel won't go there. But what do we do with the witness who's 80 years old, right? And
We do what we do in other cases. You've seen this. We know what we do.
right.
Your Honor, very candidly, Mr. Marlowe has some very strong opinions, and we will do our best, but I think the court's hit upon the issue.
Right. I'm not worried about counsel. And as far as origin is concerned, where the product's from, that's coming in. That's a material
We
fact
understand that.
of the case. But what do I do? And see, I haven't met the individual, the witness, but I've been listening, and it's been my impression that he's very opinionated.
Yes, he is.
and I accept Mr. Odou's characterization at face value, the court should instruct counsel to do what counsel can to avoid
Right.
the issue. And the court should instruct the witness, and if the witness disobeys the court, that's one thing, but I don't think that a juror is likely to hold that against any of us, which is the objective here. And if a witness comes in and uses the term illegal or talks about the Russians or Nazi hydrazine, then that reflects on the witness the way it reflects on the witness. The court's done what it can at that point, and the parties have done what they can at that point to keep the inherent bias and prejudice and uglier aspects of human nature out of the courtroom, which is all we can ask.
I understand. And Mr. Park, I know you wanted to comment.
Yeah.
You'll get the last word, sir.
You know, I think your point is well taken. The question is certainly focusing the issue now that everyone agrees that the facts are the facts. The witness is not a party. And typically when a motion in limine has been granted or denied, the attorneys will instruct their client on how to deal with that issue to not run afoul of the court's decision. This is someone who's not a party. There's no control that any of us can exert over Mr. Marlowe and how he describes his dealings. And what the court should never do is try to change the facts as a witness knows them to be. And I don't believe Mr. Neale is asking the court to in some way perverse this guy's testimony, because it is what it is. And we've been basing our case, preparing our case based on all the deposition testimony. This witness is who he is. And so if he gets up and says, despite Mr. Kemp or myself or Mr. Neale or any one of us asking him, where did you buy this product? And he says, I got them from the Russians. That's
probably
that's what's going to happen. And that's the way the case is, and that's just
He's
the
not
way it
going to
is.
say, I got it from Russia. He's going to say, I got it from the Russians.
Right.
Well, then
And
it's the
what,
question.
Scott, hold on. Let me finish before
Yeah,
you
we're
jump up, and I'll give you as much
We're
time.
going to go back to you, Mr. Rasmussen.
Yeah. And so, my point is, we're all capable trial lawyers. We understand and appreciate this guy's personality. And so you have to
When
be
you're 80 years
careful.
old, you just don't care.
That's right.
You've been around long enough, you know.
60,
That's it.
He knows I'm not going to throw him in jail.
That's right. That's what Mr. Kemp was talking about, Your Honor. It kind of reminds me of a Seinfeld episode where he says after you get a certain age, 85, 90, he says, old people quit waiting when they drive on anyone else. If they're backing up, and whoever's behind them has to wait for them. And because they don't care. And at this point, he's going to say what he feels like saying. There's nothing that we can do to prevent him from doing so. But we'll be artful and tactful enough not to walk him into it. And I think that obligation is also incumbent upon everyone on the defense side of the case. But you can't change the facts of this, and you can't change him. He's not a party.
My only thought is that I understand Mr. Parker's example of a question that could draw that sort of a response. There's another way to ask that question, and the court's indulgence would be something that's leading. In other words, you lead the witness. And it may be that in order to avoid this, we say something along the lines, in other words, we've already agreed that the leading question we can ask is, wasn't this manufactured in Russia? Yes, no. We've now avoided everything.
No, this is how he responded. Yeah, the Russians made it.
That's right.
That's exactly right.
And if he goes there after we've done a leading question, not left it open and overbroad, then there's nothing we can do.
Exactly. I agree with that.
Okay?
And what we'll do is, I guess, he's not a party, I can't control him, of course, he's 80 years old. But try to ask questions in such a manner that the pejorative term, the Russians, is not elicited from the witness. That's the best I can do.
I agree with you, Your Honor.
Yeah.
Thank you.
Very good, Your Honor.
Okay. All right, and put that in granted with that condition,
Thank you, Your
because I
Honor.
can't tell him what to do.
I'll, Mr. Neale drafted up, we'll all have a review.
Okay, all right. So let's go ahead to the next issue regarding the product itself.
The product itself, Your Honor, we're moving from the Russians to the Nazis.
Yes, we are.
This is UNFW's motion to eliminate number 6 concerning rocket fuel and German rocket fuel and Nazi rocket fuel. Again, Your Honor, I understand that Mr. Kemp, a very capable trial lawyer, is going to attempt to paint a picture. But the reason for the motion to eliminate is to make sure that, again, he doesn't take advantage of the worst parts of human nature in doing that. Hydrazine is N2H4. Can you put up the picture, John, of Mr. Blaine Jones? The hydrazine in this case, Your Honor, was made by this guy. He's an American, born and bred. He wears short sleeve button down shirts with kind of, pocket protectors and pens, and he works in, it's 2021, not 1939. It's not Dr. Von Braun. He doesn't wear a swastika or a Nazi armband. It's here in Henderson, Nevada, not Berlin, Germany. This is a case that doesn't involve certainly Nazis or Germans or rockets or fuel or spill or even contamination. It's a case of an inadvertent chemical reaction during the titanium tube manufacturing process. Every single case, Your Honor, that the plaintiffs cite is a rocket fuel spill case. When you spill rocket fuel and it gets in groundwater, it's perfectly appropriate to tell the jury that there is rocket fuel in the groundwater. When there's 300 parts per billion, Your Honor, that were inadvertently, allegedly manufactured by this guy in a titanium tube during the manufacturing process, it's not accurate to say that there's rocket fuel in the water. There never was rocket fuel in real water. It's not flammable, it has no taste, it has no odor. There's no allegation of that. Mr. Haley said it was fine, Mr. Belsky said it was fine. We're talking about concentrations at 300 parts per billion, the highest on the Eurofins testing that is 99.999997% pure. It won't fuel anything, it won't light on fire, it doesn't smell, doesn't taste different. It's simply a light organic compound that has dozens and dozens of different uses. John, if you could pull up. Let's start first with the drug study title, the neoplastic. Hydrazine, Your Honor, is a simple organic chemical compound. And like most organic chemical compounds, smart people put it into, not that one, John, I'm sorry. There's the name of the PubMed. Hydrazine is used as an anti-cancer drug. I think Mr. Kemp would probably agree that it'd be inaccurate for me to say that real water was adding anti-cancer medications to its product. The medical record, John, the one you just showed, this is a medical record of a plaintiff in the case. Can you highlight I've redacted it so that hopefully the individual's identity is not evident, but this person happened to be prescribed, if you just call out the highlighted part, John. This person was prescribed hydrazine because it's a vasodilator. It lowers your blood pressure. Can you show the drug bank listing, please, John? There are literally dozens of pharmaceutical applications for hydrazine, and this shows, I think, the first couple dozen at least. 18. How about the supplement, John? You can buy hydrazine as a supplement. If you believe this provides limitless energy, intense focus, incredible performance, and supreme confidence, I need some. The point is this, Your Honor, that there are, in addition to N2H4's use as a propellant, there are dozens and dozens of other things it can be used for. And it's not present here because of fuel contamination or fuel spill. It's not present here because of rockets. It's not present here in any of the quantities that I think a juror would assume. The opposition says that defendants do not dispute that hydrazine was invented by Germans to be used as rocket fuel. That's incorrect, we do. Hydrazine was invented by the creator, whoever that may be for me or you, and the creator put it in plants. It's naturally occurring. So to characterize it by its most sinister sounding application, especially when that application has nothing to do with the true genesis of the substance in this case, is wrong. The plaintiff's experts, Najim, Dr. Najim, who opined about its production here, wrote a 20 or 25-page report without referring to it as rocket fuel or without referring to Dr. von Braun or World War II or the Germans or the Nazis. But if we go to Exhibit B, please, John, at page 112, line 19. This is the deposition of UNFW's recall coordinator, Mr. Raymond White. He was asked, how do you know that hydrazine is used as a rocket fuel? And that's obviously fair game. Hydrazine can be, in very sufficient quantities, used as rocket fuel. And he says, well, I'm kind of a hobby rocketist. I'm a rocket hobbyist. I like this history and I've studied it. But the next question's on page 113, please, John. We go from that to Mr. Kemp asking about Dr. von Braun involved in the Nazi war effort. Next line, please, John. And hydrazine being used to power V-2 rockets the Germans used to bomb London in World War II. In two deposition lines, quicker than I could stand up to make an objection or the court could sustain it, we've talked about Nazis, Germans, World War II, bombing Allied civilians and evil scientists, and the greatest loss of life known in the last several centuries. That's the danger here. That's the picture that the plaintiffs are trying to paint. It's not rocket fuel. It never was. When you call it rocket fuel, John, the picture of the V-2 rocket, please. This is the picture you're trying to paint for the jurors. That has nothing to do with this case. Wrong place, wrong time, wrong people, wrong quantity, wrong application. Blaine Henderson, please, John. Blaine Jones. This is where the hydrazine came from. And this is the picture that we ought to be painting because that's the true and accurate one to the jury. We don't want to distort reality. We don't want to play on fear. We want the jury to decide this case based on the evidence and not make-believe villains and wrongfully borrowed sinister applications. We don't want to appeal to the emotional sympathetic. We want to appeal to the jury's intellectual ability. They have the ability, Your Honor, to decide this case without resort to ploys like that, and we ought to stay away from this the same way we did from illegals and Russians and other things of the sort. That's the motion, Your Honor, and we'd ask that you grant UNFW's motion eliminating number 6.
Here's my first question. What do we do about, for example, didn't the defense own expert say hydrazine is used in agricultural products, chemical blowing agents, pharmaceuticals?
Yes, sir. And I want to be clear. I don't mind Mr. Kemp asking an expert, isn't hydrazine used as a rocket propellant? That's fine. All the other uses are fine. Those are all true things, Your Honor. But to call this rocket fuel, or to say that rocket fuel is in the water, is a complete misstatement of fact. And it distorts the evidentiary record, and it paints an ugly picture that is not accidental, and that the court should avoid. It's one thing to say that this chemical compound can be used in a dozen different ways. And the witness can answer that question by saying, sure, it's in rockets. It's also in medicine. It's also in supplements. It's also in spandex. It's also in plants. It's also in all of those things, naturally and otherwise. And that's fair, that's accurate, that's reality, and that's what the evidence should be, not the picture that Mr. Kemp will paint for the jury if the court allows it.
Were there any jointers?
Yes, Your Honor, real water to join, thank you.
Tennessee joined as well, Your Honor.
Mr. Kemp?
Okay, let's start with the Nazi straw man they've set up, because it's a setup, Your Honor. They're trying to throw this word Nazi out there to convince the court that we're trying to use that term. They have not apparently read our opposition where we say, quote, plaintiffs have not and do not intend to refer to the hydrazine inventor as Nazis. We haven't referred to him in the case. He combined one reference out of 120 depositions to the Nazi war effort. He combined Nazi there, took that word and added it to Nazi rocket fuel and told the court that we've been using the term Nazi rocket fuel. We have not. They cannot cite that. That is something that counsel made up, Your Honor. And so we've agreed not to use the term Nazi. I don't even think we want to describe the war effort. But now, he wants us, going on from that, he wants us basically not to be able to call Coca-Cola a soda product. He wants us not to call hydrazine its primary purpose, which is rocket fuel. That is the primary purpose of hydrazine. And that's what everyone understands it to be. That's what all the learned treatises call it. That's what the cases, even the case he cited, and I'll get to that in a second, that's what they all call it, rocket fuel. Because that's what it is, Your Honor. It is rocket fuel. Can I have my first pop-up, please? Your Honor, this is from our brief. These are the learned treatise, and I could have cited.
That's page 3, right?
Yeah, I could have cited 1,000 of these, okay? This is the scientific literature. Hydrazine-fueled rockets. Well-known high-energy fuel, which has been widely used in the propulsion system of rockets. Okay, that's from dyes and pigments. That isn't talking about using this to power rockets. That's just a comment upon the substance, okay? Next one, the Journal of Nanotechnology. A specific rocket fuel, hydrazine. Rocket fuels, hydrazine. The next one, the Asian Journal. The next one, and like I said already, I could have gotten 1,000 of these, Your Honor. Every single one of them is calling it rocket fuel because that's what it was developed as, and that's the primary use of it as we sit here today. For example, the SpaceX rockets that you see Elon Musk launch nearly every week now, they use hydrazine, okay?
No more ammonium perchlorate.
Yeah, well, we had to stop that after the big explosion, yes, Your Honor. You know, but imagine in that case.
I don't remember the Pepperman explosion.
Imagine someone approaching the judge in that case, I'm trying to remember who it is off the top of my head, and telling, I think it was, maybe it was Judge White. Was it Judge White? The judge in the case? Or Judge Earl? Can you imagine
No, it
going?
wouldn't have been Earl.
Was it what?
Earl. He worked on that case.
Can you imagine the defendant filing a motion in that case and saying, oh, Judge, we can't call ammonium perchloride rocket fuel because the plaintiffs will get some kind of false benefit from it, and that's exactly what they were making it for? That's what they're doing in this case, Your Honor. In any event, that's the literature. Next, you go to the case law. The case law we cite, trying to find it real quick. The case law we cite on the top of 9. And in the case law, they call it rocket fuel. All these judges call it rocket fuel. Excuse me, that's the one to give us latitude in presenting the case, and we should be allowed to have latitude, Your Honor. This is the case that they cited, rough. So to create the false impression that there's some other primary purpose for hydrazine, they cited this rough case, and they said, oh, well, this proves that hydrazine is not used for rocket fuel, it's used for blowing agents. Okay? They took out a sentence, the very next sentence in the case, saying that hydrazine is a rocket fuel. That's how desperate they are to keep this fact from the jury, Your Honor. And I don't understand, his offer that he just made, that I can ask witnesses if hydrazine is a rocket fuel, but I can't tell the jury that hydrazine is a rocket fuel. What kind of sense does that make? Now, he says, oh, Dr. Nasher didn't use it in his expert report. Well, Dr. Goldsmith, the epidemiologist for real water, comes right out and says, hydrazine is a rocket fuel. He says that in both his original and his rebuttal report. All the studies, I shouldn't say all the studies, but most of the studies that are done on hydrazine toxicity, the animal testing by the Air Force in the 60s, the rodent testing that both our toxicologist and Dr. Possenbach, their toxicologist, rely on, all of this is done in the context of calling hydrazine rocket fuel. So, Your Honor, to suggest that the plaintiffs should be hamstrung like this for no good reason, okay? Obviously, counsel is going to get up and say, oh, well, Mr. Kemp told you it's rocket fuel. It's really for cancer, ladies and gentlemen. Mr. Jones was putting it in the real water for some kind of cancer benefit to these people, all right? If he wants to argue that, great, okay? He can argue that. He's going to, oh, the creator made hydrazine. Well, last time I checked, the creator made everything, Your Honor, okay? That doesn't mean we can't call Coca-Cola soda pop.
You do the best you can with what you have.
Right.
That's what you'll have to remember.
Right, so in any event, Your Honor, there is no basis, like I said, we have voluntarily agreed not to use the term Nazi, not to say that it was invented by the Germans in World War II, which it was. But, we won't bring that up. I think some of the witnesses will have a hard time not bringing it up. For example, he cited his own witness who started talking sua sponte about Werner von Braun and, rocket propulsion and the like. But in any event, we will not bring up the origin of hydrazine, but we should be allowed to call it a rocket fuel. And so for that reason, Your Honor, we don't mind being limited, not saying the word Nazi during the trial. We weren't going to do that anyway because we don't want to, run into a Yochi answer. I don't mind not even calling it, saying that it was invented by the Germans. There may be an editing problem or two that has to be addressed on that point, but because that was brought up by his witness, okay? His witness is the one that started talking about von Braun. But we should not be limited in any way, shape, or form from calling this substance rocket fuel, because that's what it was, that's what it is, that's what it's currently used for, that's what it was invented for, that's what it's described for in all the scientific literature, that's what the experts, including Dr. Goldsmith, have called it, that's what the cases call it. For me to be the only person in America that can't say that hydrazine is a rocket fuel, that would be an incorrect ruling, Your Honor. So for that reason, we would oppose this motion to the extent that it asks for that limitation.
Thank you, sir.
Your Honor, we've made progress. I'm glad to hear we're not going to talk about Nazis or Germans or World War II. We've heard a lot about those things in discovery. The one thing remaining is to correct the false statement that this water has rocket fuel in it. That's the only thing left that we're asking for in this motion that Mr. Kemp hasn't acceded to. This water does not have rocket fuel in it. No fuel ever came out of a rocket and made its way into this water. This water has hydrazine in it. It's N2H4. Mr. Kemp can say, is N2H4, is hydrazine used as a rocket propellant? Is it used as a rocket fuel? Yes, yes. We're not trying to deny reality. We are trying to prevent somebody from distorting it.
Okay,
Thank you, Ron.
thank you. And this is what I'm going to do, as far as the motion is concerned. It will be granted in part, denied in part. As far as the references, I don't think this is an issue of World War II, Nazis, Germans, von Braun, we're not gonna go there. As far as the development of this chemical, I guess that's what it is, really and truly. It is what it is, what its primary purpose was. And I think it's really kind of important because maybe based upon the primary purpose, if it's gonna be used for food, water, or a component in that, maybe you should be extra careful, right? And so I'm not going to preclude them from saying it's rocket fuel. That's what it was intended for at the end of the day. Because, yes, it might be trace, but maybe it was more than trace, I don't know. But the experts prefer to look that way, even the defense witnesses. It's my understanding, for example, the compliance manager said, okay, do you know what hydrazine is? Answer, I have limited understanding in the times that I know it was used in rocket fuel, right? And so, I mean, that's just the fact of the case. And we'll listen to what the experts have to say as far as that's concerned. But I can't sanitize that, right? And so, that's kind of how I look at it. That's a general understanding, and maybe that's the origin. We'll hear what they say, but I think the critical issue is word could become potentially inflammatory. It would be referring to its origin, World War II, the Nazis and Germans, the B-1s and B-2 bombs, and all those types of things. And that's just kind of how I see it. And sometimes you have good facts, sometimes you have bad things. Lunchtime, right? All right.
What time would you like us back, Your Honor?
Oh, yeah, she's reminded me, for the record, there's no jointer on file.
That's correct.
$5:26.
I must have misspoke, Your Honor. I have a list of them here. That's true.
Okay, so here's my question. And what time is your meeting again?
We have to be there at 3, Your Honor, so I would suggest we
Break it too?
break at least by 2. Well, I mean, we still gotta walk all the way out to Roger.
Well, this is my question. I mean, I'm looking at it, because when they're coming back tomorrow, day after tomorrow, day after tomorrow. And I pretty much have, in a general sense, coming back until we complete this task. My point is it worth it coming back for one motion? From a time perspective. I understand, you gotta, and I said this at the very beginning, I'm gonna be here. Right?
I don't care either way around. I think the next one's potentially gonna be longer than the council thinks.
Right, that's kind of my, what do you think, Mr. Odou?
Your Honor, we don't have a position on the next one, but it is a lengthy motion. Can we get it done in an hour? Probably not.
Yeah, I'm just looking
Again, I
at
don't have a dog in that fight, but I tend to agree with Mr. Kemp.
I'm
It's
looking
less
at this
than an
more
hour. I think
practical.
it's all 45 minutes.
You think so?
Mm.
I don't mind either way
Do
then.
you think it's 45 minutes?
At least.
Oh, at least, that's, okay. It's up to you, I'll be here, but if you don't want to come back, just come back tomorrow.
Either way,
It's up to me. We have consensus?
My thought is trying to get as many things done as possible. Is there a different motion that we believe that we're prepared for today that we could hear just to get that one done and out of the way? I agree that maybe the next one may take some time, but maybe the one after that does not take that much time, and see if we can't get that one resolved. But if we're not prepared for the one after this one, I don't want to jump the gun either. That's not fair to counsel.
we're prepared for it. We're ready to go, Your Honor.
Yeah, so. I don't mean
No,
that.
we'll do
I
that.
was not-
This makes sense, then. Let's argue the next motion, it didn't take as much time. Then after that's done, you leave, and you come back tomorrow.
Sounds great, Josh.
Does that make sense?
Okay, right now, you mean, Your Honor?
Yeah.
Okay, that's fine with me too.
Yeah, just, because it'll only take a half hour or so, get that one done.
Agreed.
Because it doesn't make sense to leave and then come back because you're eating up time. Is that correct, Mr. Robbins?
That's absolutely correct.
There's
Kept me from having to stand up, Your Honor.
Yes.
That could be very bad news, but I think the next couple motions are going to be relatively late. The next one is 7, which is preclude the 3 bottled water recall, which I think is going to be relatively long. 10A is Chris Rinn's medical records, which brings in the whole prior argument. 10B is Watkins, that's the 2018 email. That brings in the whole prior incident argument. 11 is non-liver injuries of plaintiffs, which is kind of an inappropriately titled, but that brings in the prior incident argument as well. 12, Kathy Ryerson, that one might be relatively quick, I think. 13, Converse and Desitel, I think that takes a little bit because what they're trying to exclude there are prior incidents also. 14, more prior incidents. 16, that's the, I think that's prior incident 1, 2. Yeah, that's prior incident issue. So with the exception of the Ryerson one, all the ones coming up seem to be pretty lengthy.
I think we go one more, but I think it might be good for the court and for the administration, just have maybe a 5-minute break or so. Come back to the next one that you have in order.
No problem. I don't think we have a consensus on which one.
We don't have a consensus, do we?
What do you mean on what?
On which one to go with.
Isn't it
You know what we're gonna do?
Jim's next?
Let's break.
Okay.
You know, because we do have time, okay? And that's why I try to get out of here. And because you have the meeting this afternoon with the special master, that's very important. I just want to make sure, we got to run all the way across. In fact, I know where, I've been to their new offices, and sometimes that's not an easy task to get there, right?
Yep.
And it's, if you're going down I-15,
It's impossible. I have seen this time of day. And the side
You're right.
streets are even worse.
right. I mean, it's bad. I know I tried to do something like that about a couple months ago, it was impossible. So I don't want you running around, so, what time tomorrow, man?
Almost one.
1:15. 1:15.
Thank you, Your Honor. Thank you.
Thank you.
All rise. Thank you, ladies and gentlemen.
Eric.